investigation is made and they are ready to start the company. For that they will have to file certain needed documents or certificates. Now we are going to see the second procedure, that is procedure to obtain certificates of incorporation. Certificate of incorporation, it is to be obtained from the Registrar of Companies for inception of company, that is for commencement of company or for starting the company. Following documents are to be prepared and submitted before the Registrar of Companies to obtain these certificates. So for getting the certificate of incorporation, that is COI, for getting that, first they will have to submit certain documents. Now which are those documents and which are those certificates? Let us see. The very first and the very most important document is Memorandum of Association. It is a basic document and constitution of a company. The main charter document, or you can say the rule book of its objectives and its goal. The goal and objective of company are mentioned in the Memorandum of Association. So that is the basic document of company. Provision of following clauses are compulsory in the memorandum. Which are the clauses which will be involved in the Memorandum of Association? Let us see those clauses. First clause is name clause. A public company with limited liability by the shares has to insert the word limited, and private company with limited liability by shares has to insert the word private limited at the end of its name. Company cannot adopt a name which resemble that of other company registered in India or which is detrimental to national interest. Then detrimental, that is not in favor. So in name clause, first the company will have to register its complete name, not only just the name of the company, but whether it is limited by share or limited by guarantee or it has unlimited liability. So for that particular word, that is if the company is limited by share, if a public company is limited by share, so it will insert limited after its name. That will be complete name of the company. So in this way the company will have to register or mention its complete name in the name clause, and keeping in mind that the name should not resemble to any other company which is registered in India, and the name should not be detrimental to the national interest. So the name should be in the favor of national interest, and it should not match or be a copy of any other company's name. And in the name clause, the company will have to mention its complete name. So these 3 points are necessary in the name clause. Second is address of registered office clause. That means the company has to mention the address of the registered office, so the registrar of companies and public can correspondence with company, and jurisdiction of court can be fixed. All the correspondence of company and jurisdiction of court are sent to the registered office. That means if a company is going to start, so it will have its office somewhere, and at which particular place they are keeping their office from where they are operating the company, that office should be registered before registrar of company, and that office will be known as registered office of that company. Only at that place the jurisdiction of court will be sent, and even the correspondence of public will be sent. So they will not directly contact to the company, but they will contact to the particular registered office of the company from where the company is being managed. Third one is the object clause. It is the most important clause of memorandum. For what objective and what type of business is conducted by the company is stated in this clause. The company cannot perform activity except for the goal for which the company is established. So in object clause, the company will have to mention its objective and its goal. For example, if a company for if a pharmaceutical company has been established or a medical company has been established, and in the object clause it has mentioned the particular goal or the particular object of the company. Now, if the company does anything or act anything beyond their objective or beyond the limit of their objective, so that will be void or will be considered as illegal. So in this way, the object clause is the most important. That means if the company has mentioned the objective that they will serve, they will provide medicines to the public. If a medicine company has been established and in the object clause it is mentioned that they will provide medicines to the public. Now if they come into contract with a supplier with a supplier or buyer that they will provide garments or clothes to them, so that is not under their objective, so that contract will be void. Because this memorandum of association is the basic fundamental document of company, it is assumed that every stakeholder or every person which take interest in the company, or everyone who is related with the company or who is going to deal with the company or who is going to have any contract with the company, it is assumed that they are well aware of the memorandum of association of the company. It is needed that every person which come into the contract with company, it is necessary that the one should know about the memorandum of association of the company. So in the memorandum of association of company, in the third clause of it, that is object clause, which is the most important clause, it is mentioned that what will be the goal, objective, and what will be the purpose of commencing the company, and they cannot come into any contract which is beyond that objective which is mentioned in the object clause. Fourth one is the liability clause. Liability, that means the liability of the members, which is limited or unlimited or limited by guarantee. That is to be indicated in the liability clause. In the case of one person company whose name will be entered as a second person or as a nominee in case of death or incapability of doing contract of the original person. Now in the first clause we saw that is the name clause, in which the company will have to mention its complete name, and the name should not match with the name of any other registered company of India, and uh, the name should not be in inconsistency with the country's welfare. And second one was the address of registered office, that a particular office from where the company is going to uh, manage, or from where the company is going to commence the business, that particular office, the area, location and address of that office should be mentioned in this clause. So every needed jurisdiction of court or the correspondence of public can be sent there at a registered office only. So they have to mention the particular registered office in their registered office clause in the Memorandum of Association. And third one is the object clause. That means the company will have to mention that with which purpose they are going to commence the company, and the objective of the company, the goal of the company which the company wants to achieve. And it cannot do any activity beyond the limit of object clause. Next one was liability clause, in which the liability of members is specified, clarified, that in the case of the company limited by shares, how much will be the liability of its members, and in the case of the company limited by guarantee, what will be the liability of its members, and in case of unlimited liability, how they will pay their liability. So all that needed requirements or aspects of liability of members are to be mentioned in the liability clause. Now, in case there is a one person company, so in liability clause, the whole liability is with the single person who is doing the business. So in case if the man dies or gets insane or is not able to uh, to do any contract, so in that case the liability clause will have to be entered, in which it should be mentioned that who will be the nominee uh, of that person in case of his death or his incapability of doing any contract. So in liability clause for public or private company, they will have to mention the liability of its members, but in case of one person company, the liability is with one person only, so they will mention the nominee of that company. Fifth one is the capital clause, in which the company will have to mention its authorized capital and its issued capital and the capital which they have procured. And they cannot issue shares or debenture or any kind of security over and above the limit of authorized capital. If they are authorized to issue 5 crore shares only, so they cannot issue shares beyond 5 crores. They can issue the shares within the limit of 5 crores. That means they can issue 1 crore shares of rupees 1 crore, and they can issue shares of rupees 2 crore or 3 crore or 4 crore. So in this way, the issued share capital should be within the limit of authorized share capital, and they cannot issue share capital beyond the limit of authorized share capital. So in capital clause, they will have to mention their authorized share capital and a particular fixed value, or you can say face value, of each share is to be mentioned in the capital clause. Last one is the association clause. Association, that means how many member will be associated to commence the company. So in case of public company, at least 7 members should be there, and in case of private company, at least 2 members should be there, and these members are arranged by promoters only, because until the company until the company starts, no one will get to know about the company and no one will have trust about that company. So it is the task of promoter who perform every activity before commencing the company. So he is the only one who will have to arrange those 7 minimum members for commencing the public company and 2 minimum members for commencing a private company. And those members will have to give a statement with their signature stating that they desire to establish a company. That means those minimum members will commence the company or will establish a company or will start a company. So that written consent they will have to give, and with signature. Next one is the Article of Association. It is a document determining rules of internal administration of the company. So rules for the administration of company are mentioned in the article within the boundary of the memorandum. That means the article of association should follow the memorandum of association. It includes rights of members, shares installment, share forfeiture, power of board of director, etc. Both the documents, memorandum and article, become public document after their registration. So general public, when the company issue shares, so the general public can know about the operation of company and the fundamental concept, objective, goal of the company. For that purpose, article of association and memorandum of association are presented to public, and they become public document. Because as I told you that memorandum of association is the boundary line of the company, so it is assumed that every member which come into contract with company should have knowledge about the memorandum of association of the company, because if they make any contract beyond the limit of memorandum of association, so it will be considered as void. For that purpose, memorandum of association and article of association is made a public document after the registration of company. Then list of directors are to be presented. The list of persons who are ready to work as directors is to be registered before registrar of companies. Mostly those promoters are to be appointed as directors. It is not compulsory that the director should have the shares of that company. It was in the Act of 1956, but in the Act of 2013 that is removed. So any person can be director elected by shareholders, and director is not required to have share capital or a minimum share capital. So mostly promoters are appointed as directors and they are elected by shareholders. the list of persons who are ready to work as directors is to be registered before Registrar of Companies. Yet the company has not begun, so all this work will be done by promoter. He will have to arrange the director and he will have to convince them to be the director of that particular company, and all the registration work will be done by the promoter. So in the list of director, the list of person who are ready to work as director is to be mentioned, and before registrar of company along with name, address, age, business, nationality of that director. And minimum one person must be as a female director in the board of director. Give a written consent that they are ready to work as directors in the company. Declaration of interest in any other company. Suppose I am the director of a tea company and I have a relation with a coffee company. Now tea and coffee both are substitute, and if the business will increase of tea, so it can have adverse effect on coffee, and if the business of coffee is increasing, so it can have adverse effect on tea. So for that purpose, if the director is involved in both the company, so he is favoring one company and he is making loss to other company which both belong to him. So in those circumstances, so because not to make loss to any of the company, it is needed that the director of the company or the manager or secretary or subscriber have interest in any other company. If they have, so they will have to file a statement regarding it, that in which company they are also working. That means if they are having any interest in any other company than the company in which they are working, so they will have to mention that in the declaration of interest in other company, that particular clause of Memorandum of Association. Then statement of fulfillment of the provisions of law is made. In this statement, in a prescribed form, it is to be registered before the Registrar of Companies, stating that all the above legal provisions have been fulfilled for the incorporation of company. So that form they will have to fill and present to the registrar of the company, in which they will give statement that all the information which they have provided in the Memorandum of Association and Article of Association, all the informations are true and they have followed all the legal provisions of Companies Act and are ready to be incorporated. Now when they get the done of all submission of certificates and documents, then they will have to pay the registration fees, and after the analysis and checking of the registrar, that whether they are following all rules and regulation and whether all the information are provided or not, and whether all the information are true or not. So after that inspection, the registrar, if everything is right, then only registrar will give them COI, that is certificate of incorporation. So after getting the certificate of incorporation, the company can commence the business. So in the COI, that is Certificate of Incorporation, the date on which they get the Certificate of Incorporation, that is the date of commencing the company. That means, for an example, the idea of establishing a company comes in the mind of a promoter on the date 20 June 2000, for example. So then he analyzed all the requirements for commencing the company, and he managed everything, and then on September 20, 2014, all the analysis and the work which was needed before commencing the company has been done by the promoter, and now they are going to the registrar office to file all the required documents. And now, after filing those documents, when the registrar find that everything is right, so for example, the company will get its COI, that is Certificate of Incorporation, on 13 July 2019. So now the incorporation of company will not be counted from 2000, but it will be counted from 2019 on the date when they get the Certificate of Incorporation. So from that particular date, it is assumed that company has started. In the Certificate of Incorporation, there is CIN number. As I told you, CIN number is the identification of the company. The ministry or the government does not know the company by its name, but they know the company by a particular number that is known as corporate identification number. This is 21 numeric alpha numbers code, or you can say identification number is there, in which 21 digits will be there. It will be alphanumeric number, in which there will be some alphabets and some numbers. So altogether that alphanumeric identification number is formed, and that is of 21 digits, that is known as corporate identification number. And after that, they will have to mention the authorized capital and all that, which is mentioned in the Memorandum of Association. So now they can issue the shares after getting CIN and COI, that is Certificate of Incorporation. After that, they can issue shares. If it is public company, they can issue shares to public company, and if it is private company, so they can issue shares to its limited members or to any particular institution according to the rules of Memorandum of Association and Article of Association. So in this way, when the company gets COI and CIN, then it can go for issue of shares, and at least minimum subscription which is mentioned should be there. That means if the authorized capital is of 5 lakhs rupees and the company has issued the capital of 2 lakh rupees, and the minimum subscription is up to 90%, so at least 1,80,000 share capital should be subscribed. If the company is issuing the capital of 2 lakh rupees in the form of shares, so at least 1,80,000, that is the 90% of issued capital, should be subscribed. So they should get the minimum subscription. Now let us quickly revise what we saw in this video. First we saw that in joint stock company, the process of formation of company, how the company is formed. So there are mainly two processes. First one is the promotion, which is done before commencing the business, and when all the study is made, then documents are made. Then the second procedure is to obtain the certificate of incorporation. That is done, in which they will have to form needed documents such as Memorandum of Association, Article of Association, List of Directors, Written Consent of Directors, Declaration of Interest in other company, and Statement of Fulfillment of Provisions of Law. So in this way they will have to submit all these required documents to the Registrar office. Now, as I told you, that company will go to the ROC, that is Registrar of Company, and the ROC comes under the MCA, that is Ministry of Corporate Affairs, and that will report to the government. So in this way the company have to register itself, and the government will get to know about the company by giving them, if the all details which are provided by the company are correct and they have fulfilled all the required procedure, and they have submitted all the required documents, and everything is true and according to the law and provisions of the Companies Act, then only they will get the commencement certificate, that is known as COI, Certificate of Incorporation, in which they will be provided CIN number, that is the company's identification number. So the government will know the company only by its CIN number. So it is the identification number of that company, as we citizens have the identification number in the form of Aadhaar card, in the form of Aadhaar number. So government knows its citizen by their Aadhaar number. Same way the government knows this artificial person, which is called company, by its CIN number. After getting CIN number, the company can commence the the company can commence the business, and it can issue the shares. So first process was the promotion, in which the promoter, first the idea of company will come in the mind of promoter, and then it will do the detailed investigation for that idea, whether that idea will be profitable or not, and the requirements for implementing that idea will be considered, and then all the resources which are needed for commencing the company are arranged, and it is analyzed, and the promoter see that whether all the resources required will be mobilized or not, and the location of the company is decided. And then after deciding, analyzing all the requirements, financial arrangements are made by the promoter. If the promoter perform all these activities from the idea to the execution, and till the commencement of company, if it perform every task, then only that person will be considered as promoter. Promoter can be a person or institute or group of people, and promoter is the most important person, as without promoter the company cannot come into existence. So it holds the important position for the company, and if the promoter come into any contract for the company on his own name or in the name of company, so that contract is valid. But after, if the company gets COI and it can commence the business now, so after getting the commencement certificate, the company will have to renew the contracts made by the promoter. Otherwise, those contracts which are made by the promoter for company will be considered as void. So in this way, the promoter do all the required activity from the idea to the execution of idea, and till the company, the commencement of the company, every activity is performed by the promoter. So this is the first procedure. Now the second procedure is to obtain the certificate of incorporation. For that, they will have to submit certain documents. First one is the Memorandum of Association, in which there are certain clauses which they have to mention all the required details. So the Memorandum of Association is the basic fundamental document of the company. Beyond its limit, it cannot perform any task or any contract. And in Memorandum of Association, in certain fixed clauses, they will have to mention the particular information, and they cannot go beyond that limit. You are required to maintain the order, the sequence of these clauses. Keep in mind that this sequence should be properly kept. First is name clause, in which the company will have to mention its complete name, and that name should not be resembling to any other company, and that name should not be detrimental to the national interest. Second one is the address of the registered office of company. They will have to mention in this clause that where they will have the registered office. That means from where they are going to operate the company. That location is known as registered office, which they will have to mention in this clause. And they will have to submit that information to the registrar of companies. Third one is the object clause, in which they will have to mention their objective goal for the business or for commencing the company. Fourth one is the liability clause, in which they will have to mention the liability according to the type of company. The liability of members will be decided, and that they will have to mention in the liability clause. In case it is not private or public company, it is one person company, so the liability will be borne by the one person who is the owner of the company. In case if the person dies, or if he gets insane or is not able to perform any contract, so in liability clause, the nominee, the name of nominee will be mentioned, that who will be liable after that one person, the owner of the company. Sixth one is the capital clause, in which the authorized capital, issued capital, and minimum subscription or procured capital is mentioned. In capital clause, they will have to mention the authorized capital, mainly that up to which extent they can issue shares. They cannot go beyond the limit of authorized capital. And they will have to mention a fixed price of each share. So in the capital clause, they will mention the authorized capital and the face value of each share. They can alter the Memorandum of Association if it is provided by the Companies Act. Last one is the association clause. If the company is being associated, if the company is going to be commenced, so according to the Companies Act 2013, at least 7 members should be there in public company and at least 2 members should be there in private company. Now when the company has not commenced yet, how will they get members? So that are also arranged by promoters, and they will sign in the before the registrar of company and give their consent that they will be member of of that particular company. And mostly promoters or these beginning members are appointed as directors of that company. So in this way, consent is taken of those minimum members which are required for the commencement of company. Second one is the Article of Association, in which they will have to mention the rules regarding the internal administration of the company. We will study in detail about Memorandum of Association and Article of Association in the upcoming videos. Here we are taking only an overview about this, that how the commencement of company is done. Third one is the list of directors, that who will be the director, its name, address, age, business, nationality, all the required details about the directors are given. So list is presented, then the written consent of those directors is taken, that they are willingly ready to work as director for that company. And if they have any interest in any other company, so they will have to give the declaration of that. And then the statement of fulfillment of all the provisions of law, that document they will have to submit to the registrar of company. And if the registrar of company find all the informations correct and according to the law, then only they will provide the certificate of incorporation to the company. For that, they will have to pay the registration fees, and the date which is mentioned in the certificate of incorporation, that will be the commencement day of the date of the company. And in the certificate of incorporation, CIN number is provided to the company, which is the identification number of that company. By that number only the government will know or identify that company, and then they can commence the business and issue shares within the limit of authorized capital. So in this way the company is established. Here our video comes to an end. I hope the procedure is clear to you and you enjoyed this video. With this we come to an end of this video, and now we will meet in the next video. Till then, take care of yourself and be safe and healthy. Thanks for being with me. Thank you.